All right, hi, and welcome back to another exciting episode of Vondran Legal Hour. Attorney Steve Vondran here, and we are talking about photo infringement. Okay, this is big. A lot of companies are getting letters. We defend and represent claims in the photo infringement area. These are federal copyright infringement cases. These can be filed in federal courts, and the penalties for copyright infringement can be fairly large. We have seen photo infringement cases across the spectrum, but as far as dollar amounts, but here is a case that came out of Colorado District Court in Colorado, Judge Christine Argello. And this was a case talking about photo infringement damages. This was a case where a defendant had infringed one or more photos, and the plaintiff filed a lawsuit. The defendant did not respond, and so a default judgment was taken. And when there's a default judgment, it's a two-step process. The plaintiff has to go in and first get the default, which is just telling the clerk, hey, they didn't answer in time, we're going to take a default. And step two, proving your damages. Now, if your damages are certain and liquidated, and it's obvious what the damages are, like a breach of contract, let's say you lost $70,000 on a breach of contract, the court can just enter the judgment. Other times, they may require a hearing. But this is a case about copyright infringement damages here. Eddie Malik, the plaintiff, as you can see, Berkeley Highlands Productions, the defendant, and this is an order granting plaintiff's motion for default judgment. Okay, so you can read that if you want. Plaintiff is a professional photographer in the business of licensing his photographs to an online and print media for a fee. Plaintiff photographed singer-songwriter Sebastian Burke. The photograph, maybe it was just one photograph. At all times, plaintiff has been the sole author and owner of the photograph, including all right, title, and interest to the photograph. Plaintiff then registered the photograph with the United States Copyright Office. Okay, again, if you've been watching my copyright videos, you have to register your copyrights if you want to file a lawsuit. Okay, that was the Supreme Court decision that came out last year sometime, the Fourth Estate case. So, but you have to register to file a lawsuit. Apparently, it was registered here. The infringement occurred after the registration, so that entitles, when that happens, the plaintiff can seek attorney fees as well as statutory damages, or if their actual damages are higher, if it's a $200,000 photo, you can sue for $200,000, the actual damages. So the plaintiff gets to elect the remedies in copyright cases, okay? So here we say the plaintiff filed a lawsuit claiming a violation of their exclusive rights to reproduce, publicly display, distribute, and or use the photograph on defendant's website. So the exclusive rights were violated. The court entered the default right here, entered pursuant to Federal Rules of Civil Procedure 55A. If you want to know more about that, I do have a video out. Somebody's calling now. I do have a video out that discusses default judgments under Federal Rules Civil Procedure 55. Google that, Attorney Steve, default judgments. You'll probably find my video, okay? So here the plaintiff sought $30,000 in statutory damages plus reasonable attorney fees. Now, the way it works in copyright law, basically the minimum statutory damage is $750 per infringed title, per infringed number there. And so, but it goes up to as high as $150,000 for willful infringement. So as a plaintiff, if it's willful, if you have facts alleging willful infringement, you need to get that in your complaint, because if they default, you're going to be kind of stuck to your complaint. So you want to get all your facts out there in your complaint. That's kind of the moral of the story in this case, it looks like. As a result of the motion, it was sent to the judge. Judge here heard the exhibits, affidavits, and applied the law. The court granted plaintiff's motion for default judgment, so that was good. Court talks about default judgment. If you don't answer, what happens. If you want to read that, pause the video, and you can read that. And talks about the two-step process I just talked about. To enter the default, here you go, the two-step process. But they go on to talk about the actual damages the court's going to award here. And it says, the Rule 55B, the court may conduct a hearing, but the court doesn't have to if it's easily calculated in a liquidated sum or capable of mathematical calculation. The court can just enter the judgment. They don't have to hold a hearing. A live hearing may be required. They're called prove-up hearings, where you have to go and prove your case. So there it is. So basically that was the, and here's some talk about the damages. If you're stuck in a photo infringement case, damages may be awarded only if the record adequately reflects the basis for the award via a hearing or demonstration by detailed affidavits establishing the necessary facts. So, your photographer can give a declaration as to what they've licensed their photos for in the past, kind of give the details of their brand and how much they charge and, the use at issue, what kind of charge would there have been, those kinds of things. Doesn't mean that's what you're going to get, but, you need to allege these facts in your complaint if you have them. So again, courts have to make sure there's jurisdiction. If you're suing in Colorado, you want to make sure that the defendant is in Colorado and not up in New York or something. So the court has to take a look at that. And what else do we have here? You can pause this if you want to read this. Here it says defendant is a Colorado resident, so that was no problem getting the jurisdiction in Colorado in the district court. So let's go down. Here it is. Violation of the Copyright Act. The copyright owner has the exclusive right to reproduce the copyrighted works in copies or phonorecords, to distribute, in the case of pictorial, including individual images, to display the copyrighted work. So these are violated when somebody takes a photo, uses it on their website without consent, without a license. These exclusive rights, here it is right here. Anyone who violates these exclusive rights is an infringer. That bad little word, infringer. Okay, so in here, and what happens in these complaints? The allegations of plaintiff, as long as they're plausible, the court will accept them as true when somebody defaults. That's why you want a really nice, detailed complaint setting forth, the grounds, that kind of thing. Okay, so as such, he has the exclusive rights. It was violated when defendant used this photograph on its website to advertise and promote a concert. So maybe it was one photo. Defendant did so without permission. As a result, it was copyright infringement under 17 U.S.C. 501. So here we go into statutory damages. They were seeking $30,000, as you can see. The court has, as I mentioned, for non-willful infringement, this is like sort of innocent, the court may award $750 up to $30,000. Here's the key word, the key phrase, the phrase that pays, as the court considers just. As the court considers just. So the court's going to weigh everything, decide what a fair award is, and they're going to consider the nature of the copyright. Sometimes like a Disney movie might have more value than a photo of a building or something like that. So they're going to consider the nature of the copyright, the circumstances of the infringement. For example, if you send a cease and desist letter, somebody doesn't take down the photo, they're acting in a willful manner, you can make these allegations. So long as the amount is not less, neither more than the maximum, that's $150, nor less than the minimum, $750. Now, there is some case law that says where it's innocent infringement. If you need to know more about innocent infringement, Google Attorney Steve, innocent infringement. I have a video on that, on what innocent infringement is. Damages could be as low as $200, but there are some requirements for that, okay? Court says, continues, not merely compels a restitution of profit and reparation of injury, but also an amount designed to discourage wrongful conduct, okay? So put more bluntly, courts must put defendants on notice that it costs less to obey the Copyright Act than to violate it. So there's a key phrase for you. So an amount that puts defendants on notice, you should have just licensed it. So there has to be some kind of penalty is what this court is saying, okay? Courts have awarded statutory damages that are between 2 and 3 times the license fee. So if your license fee is $2,500, courts have awarded $5,000 and $7,500, and more, plus attorney fees, okay? So they were seeking $30,000. Plaintiff asked the court for $30,000. Court says no. Court says no. I'm not going to do $30,000. We're going to do $750. We're going to do the minimum, the court says. So plaintiff cites several New York cases where upon a default, as I said, cases are all over the board. $30,000 upon damages was proper upon a default. So there is precedent for $30,000 in damages. But this court said, no, plaintiff fails to explain the basis for his argument that $30,000 would deter willful infringement. The court talked about the complaint being devoid of any factual evidence germane to how defendant's infringement was willful. So this is the key. When you're representing photographers, the key is to get those allegations in of willfulness, showing that there was either intentional or just a reckless disregard of the copyright holder's rights. Okay, reckless disregard. So look at the facts, see what's going on in your case, and that may help you make your allegations. But you need a well-pled complaint because some defendants are not going to answer. They're going to get a default, and you want to be able to easily show your case, prove your case, and get those damages up, okay? For example, there are no allegations as to whether defendant was contacted by plaintiff to inform him that he owned the copyright or to offer a license. Okay, so that's another thing. You may want to say, well, look, we're willing to offer a license and X amount of dollars. That may need to go into your complaint that defendant was not willing to pay any reasonable licensing fee, okay? So these are some of the things that are important. This is a key photo infringement case that just came down. I wanted just to give you this IP breaking news. Attorney Steve Vondran, attorneysteve.com. Other things you can say is that they repeatedly reject and ignored offers of licenses. There's another court's laying out a few arguments that it would have considered. But again, they point out it could be for non-willful infringement, $750 to $30,000 as the court considers just. So it's going to be up to your judge. It's why I tell my clients, you always take a chance when you want to go to default. Judge could award $750 like this case. Judge could award $30,000 relying on the New York cases. So it's a risky proposition to take a default, but here's what you're looking at, okay? So sometimes you want to take a close look at your complaint. What does it say? Is it alleging willful? Does it have facts to show willful? Some people will take their chances and take a default. But just bear this in mind, okay? So again, the courts are going to look at the deterrent purposes of statutory damages. They want to make sure people don't do this again. Let's go down here. Also, I like this one. The court has recognized that infringers should not be free to sneer in the face of the Copyright Act. They should not be free to sneer in the face of the Copyright Act. And the courts, again, must put defendants on notice that it's costs less to obey than to violate. Okay, so going on down here, see here we have it up to $150,000, as I showed you, maybe increased up to $150,000. I'm not aware of any photo infringement cases that hit $150,000 or even $100,000 for that matter. But if you have multiple photos, you certainly do have to be careful for that, okay? And here it is, as court said, the court must rely upon, and it's bolded here, something other than the goal of deterrence to exercise its discretion and determine an appropriate amount of statutory damages. So you need something, some supporting documentation, something here. It's in bold, something more than just, hey, we need to deter and I need 30 grand, judge. Okay, so the court awarded the minimum of $750 to plaintiff. And then under the Copyright Act, you can also seek attorney fees. Here, the court said the plaintiff asked for $2,500 in attorney fees plus $450 in costs. That would be your cost to file your lawsuit and possibly service of process fees. You got to serve your complaint and summons on a defendant. And this, the court says, was adequately documented with an affidavit from the plaintiff's attorney, documentation, total hours worked, the rates charged, the work performed. So that the judge found to be reasonable. So at the end of the day, you take the 750, you take the 2550 conclusion, 3740. There's your judgment. Judge Arguello, United States District Judge. So that's a little primer on copyright photo infringement. People ask me, what's it going to cost? I say, I don't know. We need to look into the facts. We need to see what's going on. We need to look at the circumstances and take a look at it. Many times these cases are better to settle rather than roll the roulette wheel and see what happens. But every case is different. This is general legal information only and not legal advice. If you need help with a photo infringement claim, we help plaintiffs and defendants. We do photo infringement, intellectual property law. Give us a call. You know where to find us on the web at attorneysteve.com. That's attorneysteve.com, the first name in legal services. I hope you like this video. It's a very, very good, important video to know if you're getting a photo infringement letter, like Higbee and Associates. They send a lot of photo infringement letters. There's other firms as well. If you get a letter, give us a ring. Let's take a look. We offer low-cost consultations to help guide you through this, and we do help plaintiffs in recovery actions. Okay? Thanks a lot. Have a great day. I got to run. Bye now.